Right, so thanks again everyone for joining us. I'm Rebecca Pezzutti, the Legal Practice Director at IRiQ Law. With me today is Abbey Glacken, who is an associate in my team. And today we're going to talk you through navigating unfair dismissal claims as an employer and hopefully leave you with some effective strategies for handling dismissal disputes and staying out of the Fair Work Commission. Just in terms of some housekeeping, all attendees are off camera and muted, and we will supply the slides and the recordings post-event. I do invite you to ask questions as we go by using the Q&A function. There's a chat and a Q&A box in the Teams format that we're in, so you can use those. Abbey and I will moderate those during the discussion to make sure that we address answers as we go. The information presented today is general information, not legal advice. If there are any things that we discussed today that reflect some things that are on your mind and you've got further questions, please feel free to reach out to the team. Okay, so in the time that we've allocated today, we'll cover these key themes which commonly arise in unfair dismissal litigation and where they're present in any given set of facts require careful consideration based on what we know about how the Fair Work Commission approaches these issues. In that respect, whilst at times unfair dismissal decisions and the jurisdiction can produce results that on face value seem counterintuitive or overly employee friendly, there is a fairly consistent trend in the Commission decisions with respect to these particular themes. And to that end, we think some useful guidance that employers can have some confidence in. So we'll start with an introduction, which I'll cover, then go into a discussion about recent cases dealing with lawful and reasonable directions. We'll discuss adequate policies, some of the process matters arising from particularly disciplinary processes, some diversity and communication considerations, and genuine redundancy, which is clearly on everybody's minds post the High Court decision in Helensburgh Coal. We'll also have some dedicated time for questions at the end, but like I said, feel free to ask those as we go by popping them in the chat and in the Q&A functions. So in terms of our experience in the Fair Work Commission unfair dismissal jurisdiction, well, we know that the Commission regularly produces data about the number of filings each financial year in both unfair dismissal and general protections jurisdiction. And this generally confirms what we already know, that many applications are filed year on year. For example, in 23-24, there were just over 14,500 unfair dismissal applications filed and just under 5,500 general protections claims. In 24-25, those numbers climbed to 16,500 unfair dismissal claims and just over 6,000 general protections claims. Anecdotally, the presence of paid agents, that is non-lawyers who appear as advocates in the Commission, is driving up filings as paid agents and advocates pursue a business model around unmeritorious claims designed to extract commercial settlement. However, it is also fair to say that a high level of community awareness around unfair dismissal has arisen from high-profile and high-value general protections cases, which get incorrectly reported in the media as unfair dismissal claims. And I think there's some good examples of many other employment-related claims that are frequently reported in the media as unfair dismissal, notwithstanding that that's actually not the true legal nature of the claim. And so that results in a higher level of individual awareness and expectation about what can be achieved in these jurisdictions. According to the Fair Work Commission President Hatcher, in statements he made recently at an IR conference, Around 2/3 of general protections applications are made by individuals who don't meet the unfair dismissal jurisdiction threshold around qualifying periods. And so as a result, we're seeing a business as usual alternative to unfair dismissals in the approach to general protections, which overall reflects the high degree of likelihood of those claims being filed. Now, it's not just about the numbers. After all, unfair dismissal in the Fair Work Commission is uncapped. It's a capped compensation jurisdiction with the maximum achievable award at 26 weeks or around 91,000, whichever is the lesser. That gives employers some degree of certainty around the worst case scenario for awards of compensation in unfair dismissal, but may lead to a false sense of security around the outcomes that are likely to be seen in any individual case. Historically, it was uncommon to see the maximum amount of compensation awarded, but we're seeing that change. And what we're also seeing change is the prevalence of reinstatement orders, which are arguably even more problematic for employers than compensation orders. So whilst it's not the case that all dismissal decisions are high risk, it is more common for employers to be contemplating whether or perhaps the likelihood of an unfair dismissal application in response to a dismissal decision. And because the low bar of entry to the unfair dismissal jurisdiction is such that there is an absence of any application screening or preliminary assessment at the time of filing, more often than not, employees and their advocates have very little to lose by filing an application, regardless of its merits. Having said all of that, unfair dismissal claims may appear at times inevitable, but one of the things that remains true from our experience is that the investment in de-risking dismissal decisions puts employers in the best position to defend their decisions, regardless of the reasons. And so, taking our lessons from the cases, we're going to explore some of the most common themes, starting with lawful and reasonable directions. Now, whether a direction is lawful and reasonable and a failure to comply with that direction would found a valid reason for dismissal will always be fact and context specific. However, to the extent that employment contracts and policies have a bearing on that assessment, the Fair Work Commission will generally be looking for evidence that the employer has a clear policy on the issue, has inducted and trained the employee about the existence and operation of the policy, and has consistently applied the policy across its workforce. Where the terms of an employment contract are relevant, an express term permitting the direction or acknowledging the employee's agreement will always be preferable to an implied term. In a recent decision of Tamati and MQT Proprietary Limited, that was demonstrated well in the summary dismissal of a manager. She was summarily dismissed a few days after she had been suspended in circumstances where she had attended a boozy lunch with two of her colleagues, and 4 hours later, they had returned to the office and became disruptive. A director of the employer organisation suspected them of being intoxicated and instructed the HR manager to conduct a breath test. There was a policy in relation to that, which permitted the employer to conduct a breath test either randomly, post-incident for cause, or based on suspicion. When the HR manager approached the group of three who'd been out to the boozy lunch and requested that they participate in a breath test, one of the lunch attendees admitted they'd been drinking, refused to participate in the test, resigned and left on the spot. in that respect, making things easy for the employer. Ms. Tamati, though, having been called into a meeting room and asked to undergo a breath test, initially said she would take the test, but questioned the grounds for the request. And she was given varying explanations, from random testing, post-incident testing for cause, and suspicion-based testing based on her attendance at the lunch and her behaviour when she returned to the office. Ms. Tamati continued to ask for clarification, and ultimately she refused to undergo the test on the basis of her view that her employer had no valid or proper grounds to subject her to a breath test. The employer told her that if she continued to refuse to participate in the breath test, that would lead to her suspension and possibly dismissal. She did continue to refuse, and so she was suspended with pay while the employer undertook an investigation. The next day, she was interviewed by the HR manager. She asked for written allegations and the policy. The policy was provided to Ms. Tamati during that meeting, and she was told that the employer relied on the policy to contend that if she failed to comply with a lawful and reasonable direction, that she had failed to comply with a lawful and reasonable direction, and that may justify dismissal because it amounted to serious misconduct. Ms. Tamati said at that meeting that she felt ambushed, unfairly associated with her colleagues' behaviour, and that the basis for testing was unclear. On that ground, she continued to refuse to participate, and the meeting concluded with a summary dismissal for serious misconduct. A termination letter sent the next day confirmed that she was dismissed for refusing a lawful and reasonable direction to undergo a drug and alcohol test. And her attendance at the long lunch, alcohol consumption, and her unusual behaviour or disruptive behaviour was a ground for the suspicion for that lawful and reasonable direction to be given. In the Fair Work Commission, when she claimed that that was an unfair dismissal, the Commission was critical of the employer's policy. And although the employment contract, required Ms. Tamati to comply with policies and lawful directions, and also allowed for summary dismissal for a refusal, the Fair Work Commission was critical of the drug and alcohol policy because it didn't state what the sanctions might be for refusing a test, although it did set out the sanctions for a positive or non-negative test. The Fair Work Commission was also interested in the employee handbook, which outlined some disciplinary processes, including warnings, counselling, demotion, or dismissal. And in ultimately finding the termination harsh, unjust, and unreasonable, made a few significant findings. The first was that it wasn't satisfied that Ms. Tamati's behaviour did meet the required signs for suspicion of intoxication, which were set out in the policy, that the policy didn't otherwise specify dismissal for test refusal, and that no proper investigation or alternative disciplinary measures were considered. And in this case, the Commission did award the maximum amount of compensation for Ms. Tamati based on her earnings, which was $63,500. So the takeaway there is about the importance of clearly communicated, consistently applied policies, but also being explicit about the consequences of non-compliance. The next case that we'll discuss is Mowers and the trustee for the Williamson Family Trust. This is an entity that traded as Firefly Lighting, a commercial lighting manufacturer, and Mr. Mowers was a senior relationship manager. It's a fairly long decision of the Fair Work Commission, which is somewhat unusual for unfair dismissal cases, and it kind of has everything in the sense that there was the employee made some complaints about the workplace, was the subject of some performance and disciplinary action, had travelled overseas after being while on sick leave after being refused a request to work remotely. So in some respects, there was a lot of mud in the water in this case, but the key themes in relation to the Commission's consideration was around whether a direction to provide access to medical information was lawful and reasonable. So that was against the backdrop of an employee putting aside some of the other contextual factors, was planning to travel to New Zealand. And before he left, he asked to work remotely while he was there. That request was denied because there were some logistical issues, and I've got no doubt reasonable business grounds for that refusal. Before his departure, though, for New Zealand, he was subject to a disciplinary meeting, or invited to a disciplinary meeting about performance and conduct, which had been in train for some time, but called in sick on the day of the meeting and then went to New Zealand. He also submitted medical certificates for the period that he was in New Zealand, stating that he was unfit for work. And those medical certificates were vague, didn't go beyond saying that he had a medical condition. So, not surprisingly, against the backdrop of an employee who was already planning to travel to New Zealand, had made a request to work remotely from New Zealand, and instead of taking leave as directed, had submitted vague medical certificates about his capacity for work for the same period, the employer had some questions for this employee about what was really going on. The employee also submitted a certificate that said he could probably manage some matters remotely, and indicating that he might actually be able to work remotely from New Zealand, a request that had previously been denied by the employer. So, on questioning the adequacy of the medical information and requesting further evidence, the employer asked for permission to write to the employee's GP and allow the GP to answer questions about his fitness for work remotely in New Zealand while he was apparently unwell. And I suppose, as a side note, one of the other factors rolling around here was that he was posting on social media about how much fun he was having on his New Zealand holiday. So that's in the mix as well. The employer said to the employee, "We need this information for work health and safety considerations about your ability to work remotely." And so there's a lawful and reasonable basis for that request. Mr. Moores continued to refuse and said that he had privacy concerns and that it was not legally required for the employer to have a fitness for work assessment to work remotely from New Zealand. What ensued was essentially a standoff via email about whether it was lawful for the employer to make that request. And as an advisor to HR and leaders and managers dealing with these kinds of issues frequently, I was quite interested to read the back and forth, knowing that Mr. Moores was not on a winner, and this was probably destined to end up where it did, given the tenor of some of those email communications. Ultimately, the employer did dismiss Mr. Moores, having warned him that a failure to provide his consent to the provision of that medical information would be treated as serious misconduct by way of a failure to comply with a lawful and reasonable direction. In the Commission, not surprisingly from our point of view, the Commission said that was lawful and reasonable because under the contract, the employee had actually agreed that he would provide that consent if required in the context of work health and safety matters. And so a refusal constituted serious misconduct, which is defined to include conduct that demonstrates an intention not to be bound or perform the terms of the employment contract. That's not a surprising outcome, but what was interesting about this decision is Commissioner Simpson, who's a commissioner in Brisbane, made the observation that it might not have been, or actually said it wouldn't have been, lawful and reasonable if it wasn't an express term of the contract. That approach doesn't sit necessarily well with federal court authority that has previously established that a term will be implied into the contract with respect to medical assessments when required for safety or operational planning purposes. However, there is some slight nuance and distinction here because ordinarily, an employer in the position that Firefly Lighting was in might say, okay, if you won't let us talk to your GP, we're going to send you off to an independent medical assessment. And that's justified because of work health and safety considerations. And there's never really going to be any doubt based on established precedent that that is a lawful and reasonable direction. So what this decision really does is say, if your contract has the GP consents built into it, then your direction is always going to be lawful and reasonable, which I guess brings us to some takeaways around revisiting employment contracts to ensure that they include those consents and the circumstances in which it will be necessary to require them. All right, so moving on then, Abbey, I'll hand over to you to talk us through the adequacy of workplace policies.
Thanks, Rebecca. So what I'm finding in some of the recent decisions that I've been reading is that employers are generally halfway there when it comes to breaches of policy. They've got the policy in place, they've referenced a breach of policy in the disciplinary process in the lead up to dismissal, but the Commission is finding that that's not enough, either because the employee is not aware of their obligations under the policy or the policy itself is not clear, like you mentioned earlier. There's two cases that I recently read that interested me, both around drug and alcohol policies. Not surprising, I guess, in this era where employers are looking towards their obligations from a safety perspective and treating these policies quite strictly. But unfortunately, due to different matters in each of these cases, they were let down because of their policies. So the first case is Hannock and Sydney International Container Terminals. So the employee, Mr. Hannock, was a long-serving employee. He had actually breached the drug and alcohol policy before, though there was some dispute around the warnings that were provided in the hearing. But at the time that he breached a policy, and his knowledge was that the limit was 0.02. DP World later changed the policy to a zero limit after consulting with their Work Health and Safety Committee, emailing staff the updated policy and advising them of the change in 3 to 4 minute toolbox talks. Sometime after that, an incident occurred at work and Mr. Hannock returned a reading of 0.017. DP World commenced a disciplinary process and terminated him for serious misconduct for breaching the policy. So Mr. Hannock ended up filing an unfair dismissal claim, arguing that he was not aware of the policy change, amongst some other reasons. So in the hearing, Deputy President Wright spent a lot of time considering whether the employer took reasonable steps to communicate the policy to employees, looking at the workforce, which was, machine operators that didn't really spend any time on their emails or computers during their shift. DP found that emailing a policy and expecting employees to read it, particularly outside of work hours, was not enough, given the significance of the change and the impact it would have on employees. The Deputy President provided some practical guidance for employers to communicate policy changes to employees, particularly where they do have significant implications, including having a dedicated training session in relation to the changes, which tests employees' knowledge of their understanding of the requirements and getting signed confirmation from employees that they have read and understood the changes to the policy. Ultimately, this was one factor that led to the Deputy President finding the dismissal was harsh. They also considered the employee's age and length of service, and the fact that that reading would have been compliant with the prior policy that he was aware of. Ultimately, this was one of the decisions that did end in reinstatement, which is a matter the employer obviously would have to deal with following this decision. Another case similarly in a similar workforce, a terminal with machine operators, was Witherden and DP World, Sydney. And this was another long-standing employee who had been employed for over 25 years with a generally favourable record. There were some personal circumstances leading up to the dismissal where the employee sustained an on-the-job shoulder injury, which led to a painful recovery, and he began self-medicating with illicit drugs. Different to the previous situation where the drug and alcohol test was administered after an incident, this was the result of a random drug test, which confirmed that the employee did have the presence of cocaine metabolites in their system. Again, following this, a disciplinary process was commenced. The employee provided extensive response about his personal circumstances and what had occurred leading up to this test. However, ultimately, the employer terminated him for serious misconduct. Again, this was similar in terms of filing the unfair dismissal, but it wasn't as much in relation to not being aware of the policy, but the policy itself not being clear about what it meant to be fit at work and the options other than dismissal in the circumstances. So again, Deputy President Wright, they spent a lot of time considering whether the information available to employees about the policy was adequate. The Deputy President pointed out two main concerns with the policy. The first is quite technical in terms of the difference between testing positive to cocaine compared to testing positive to cocaine metabolites. There's a lot of technical jargon in the dismissal decision around the difference between this. I understand the cocaine metabolites is sort of the after remnants, but not the parent drug. So there is a difference between that and the impairing effects. And the employee made arguments about not being impaired and feeling fit for work. So there was some consideration around that and that not being clear in the policy what actually was being tested. And the employer should have been more clear about this and explained what it actually means to employees to be fit at work. The second was some conflicting statements in the policy itself about when disciplinary action may be taken. So the policy had a strong focus on rehabilitation and helping employees with rehabilitation plans if they had come forward with, reasons around, dependence on drugs and alcohol. And the Deputy President said that this should have been in the consideration of the employer in terms of mitigating risk before further disciplinary action was taken as well. So I think some important call-outs just in relation to policies is that it's really important to have key terms defined in policies, such as what it actually means to be fit at work if you're intending to rely on that in disciplinary processes, and also setting out the consequences for breaches. So if you're saying that rehabilitation is a focus of the policy, that should really be coming into mind when you're making decisions. Ensuring employees understand their obligations and consequences under the policy. What does it actually mean to test positive to a drug, and what are those drugs? And again, conducting regular refresher training on policies and keeping records of attendance at this training. Obviously, how this is done will be really dependent on your workforce. In the first case, there were machine operators. They're not at a desk every day reading emails that come through, and a 3 to 4 minute toolbox talk is not a substantial amount of time to explain a change in a policy. Perhaps setting aside more time to actually run people through the changes or through a training module, whatever works for your workforce, and keeping attendance of that training, because that will become important if it does come into dispute at a later time frame, if the employee was actually aware of the policy or not. So the next point that's come up in a few, well, probably most unfair dismissal cases, is the process itself. Even with a good policy, sometimes it's the actual process that lets the employer down. So it is always important to ensure that you're following a procedurally fair process. There's some recent guidance on what is and isn't a good process. So in the first matter, Callow and people, the facts of the case were that Ms. Callow was a dump truck operator at a mine, and she was assisting with organising a fundraiser for a colleague who had been diagnosed with cancer. The fundraiser involved employees buying a number of different coloured shirts to show their support, and Ms. Callow was organising this with the assistance of her supervisor. Ms. Callow was wanting to progress the fundraiser and sent a number of emails to her supervisor to understand how to do this. Following not receiving a response from her supervisor, Ms. Callow firstly obtained personal email addresses for employees, and then emailed 850 employees regarding the fundraiser. Employees had raised concerns following this because their personal email addresses had been shared, which led to a disciplinary process. The investigation itself was conducted by the HR business partner, and then the following disciplinary process and termination was also conducted by them. So the allegations put to Ms. Callow was that she knowingly disregarded instructions by her supervisor, which ultimately became a factual dispute in the hearing, and breached multiple policies, including the privacy policy. Ms. Callow provided an extensive response outlining that it was a genuine mistake. She meant to BCC everyone into the email rather than copy them, and she felt time pressure to progress this fundraiser in the circumstances for her colleague. And because she hadn't received instructions from her supervisor, she progressed with sending the email. There were quite a number of issues with the process in this one, particularly the HR business partner managing both the investigation and the disciplinary process, and receiving input from the supervisor about that disciplinary process, which is clearly a conflict of interest, where Ms. Callow's response related to instructions that that person didn't provide. Ultimately, employees need to provide that separation between the investigation and the ultimate decision maker. Similar to the previous cases, there were also some issues with the obligations on employees in the privacy policy not being clear, and Ms. Callow's understanding of these obligations being much of a tick and flick exercise when she commenced employment, particularly in her role as a dump truck operator, not having access to emails as well, or not using emails on a regular basis. And during the hearing, it came up that, well, the employee raised some evidence that other senior employees had shared personal information, weren't treated in the same way, and the same notifications weren't made to staff after those instances. So ultimately, a number of those factors led to the finding that the dismissal was unfair, particularly around the policies not being adequately explained, her being unsupported by the senior employee, the conflict of interest in the investigation process and decision making, and the appeared differential treatment of staff as well. Again, this was an order for reinstatement, which comes up in quite a few of these cases we speak to today, and obviously there's a we won't get into it today, but difficulty with reintroducing the employee into the workforce. I won't speak too much on it, but another matter that came up was that the conduct itself was classified as serious misconduct, and Commissioner Spencer pointed out to the employer the definitions in the Fair Work Act and regulations, and couldn't find facts that it met this threshold, as there was no evidence of a lawful direction, and the conduct was not willful or deliberate behaviour that was inconsistent with the continuation of her employment as a dump truck operator. So I think this is just a really important reminder as well to not be throwing around serious misconduct unless further consideration is given to whether it actually meets that threshold. I won't spend too much time on the next case, but I just thought it was an important reminder for employers, particularly some of our clients have come to us where they've taken a more empathetic approach at the start of a matter, particularly relating to a person's personal circumstances, and then after a period of time want to take a stricter approach. Essentially, Deputy President Coleman in this matter did find that Woolworths' tolerance over a number of years may have been seen to contribute to instilling a sense of impunity in the employee, but in this matter, their view was that it didn't preclude Woolworths from deciding to take a stricter approach later on, particularly where the non-compliance was not singular in nature, but repeated and of substance. So in the context that obviously an employee doesn't turn a complete blind eye and demand compliance overnight, there can be an escalating disciplinary process that perhaps is conducted over a significant amount of time and is still considered to be fair in all of the circumstances. Obviously, these types of matters will turn on the facts of the case, and there was a number of instances of non-compliance rather than just one here. But just a reminder for employers that you can take an empathetic approach first, and that doesn't preclude you from taking disciplinary action or more significant disciplinary action down the track if it is managed consistently. So just a few takeaways from those matters is consistency in the way policies are managed and disciplinary processes are managed in terms of making sure that employees are held to the same account, having separate and distinct decision makers, particularly where an investigation is involved, and the importance of documentation, so keeping proper documents of disciplinary actions and who the decision maker was and the reason for decisions in the case that you do need to defend a challenge at a later point. So something else that we've recently experienced in our practice, but also what we've been seeing in cases as well, is employers not managing cultural and language considerations as part of disciplinary processes, particularly where employees have limited English proficiency. I think as HR and legal practitioners, we can often get caught up in following a process to a T, but sometimes it is important that we allow some flexibility to ensure it fits the circumstances that we're dealing with. So the matter that came up recently that I saw was Shah and Real Dairy Production. Quite a short decision, but a good reminder for employers. The employee in this matter spoke limited English. The employee had concerns with the employee's conduct, including being aggressive and non-conforming on a number of occasions, resulting in a formal warning being issued, though the employee disputed receiving the formal warning. And then he was ultimately dismissed following further alleged incident. It's not surprising that the employee brought an unfair dismissal claim, arguing that the dismissal came as a shock and not understanding the warning or being given an opportunity to respond. Obviously, a few procedural matters there, but I think ultimately the Deputy President in this case really focused on the fact that the employee didn't understand the warning or the disciplinary process itself and the potential outcomes, and commented on the employer's witness statements, particularly, which were not signed. They were general in nature. They didn't actually make good any of the assertions they made in their written application, for instance, providing details of the actual incidents they relied on in relation to the formal warning. And although the Deputy President acknowledged that there might have been some difficulty in managing the employee, the employer should have done a better job in communicating its expectations to the employee, so there was no doubt about the expectations. Ultimately, the Deputy President found the dismissal unfair, as he wasn't given an opportunity to respond, and his personal circumstances as well. An interesting part of this matter is that the Commission decided to have the decision translated into the employee's first language to ensure that the concerns that led to his dismissal were clear to him. I think that just leads into a few key takeaways for managing situations where there might be cultural considerations. As a reminder from the Commission in that matter, potentially using translating services when required, whether that's during investigations or disciplinary processes, if you have an employee with limited English proficiency, incorporating cultural competency into disciplinary procedures, whether that's seeking some expert advice on how to manage a particular situation or cultural area, and verifying employee comprehension through a follow-up discussion or in writing. Make sure that the employee actually knows what the expectation is or the outcome of a decision. I think, again, often as HR and legal practitioners, we expect that people understand the terms that we're using every day when we talk about standing someone down or a warning. Those things are not always clear to people, so make sure that you do take those extra steps to ensure they understand it, rather than just issuing a formal warning and feeling like you've done what you need to do from a procedural fairness aspect. I think that is probably enough talking from me now about some of those cases. I'll hand back to Rebecca to talk about genuine redundancies.
Thanks, Abbey. All right, so moving on then to the High Court decision in Helensburgh Borough Coal and Bartley, a decision I've no doubt all of you, or if not at least most of you on the call, have heard about. I think it's fair to describe it as epic litigation over 5 years, beginning in 2020. and ultimately dealing with the scope of the employer's obligation to consider reasonable redeployment in the case of redundancy. Bearing in mind that this is an unfair dismissal claim and we're in the High Court, not necessarily from the monetary value perspective, high stakes, but this concerned 22 employees and was backed by the Mining and Energy Union, and ultimately challenged or sought to challenge the use of contractors. And I think it's fair to say that from a union agenda perspective, it was probably seen as a good opportunity to have those issues fully exploited. And from the outset, the applicant employees did have ultimately the decisions in their favour, apart from one full bench appeal that was remitted for rehearing. All of the courts below the High Court effectively said the same thing. So let's have a look then at what the High Court said. So it's a decision that was handed down on the 6th of August this year. The High Court unanimously dismissed an appeal from Helensburgh Coal, challenging a decision of the full court, of the Federal Court, about the scope of an employer's obligation under 389 of the Fair Work Act, and in particular, the requirement to require an employer to consider redeployment of redundant employees where reasonable in all the circumstances. So just going back to recap 3892 of the Fair Work Act, it deals with the meaning of genuine redundancy, and it's a defence to an unfair dismissal claim if the employer is able to establish that the dismissal was a case of genuine redundancy. 3892 says it won't be genuine redundancy if, and there's some other, not relevant to this discussion, some other qualifications, it would have been reasonable in all the circumstances for the person to be redeployed within the employer's enterprise or the enterprise of an associated entity. So in July 2020, like I said, 5 years before we get the High Court decision, 22 employees were made redundant by reason of a restructure by Helensburgh Coal. The employees, backed by the MEU, applied to the Fair Work Commission for an unfair dismissal remedy, saying that they could have been redeployed into other roles that contractors were performing. And Helensburgh Coal said, response to that was no, the dismissals were a case of genuine redundancy because it reflected the impact of organisational change on employees. Helensburgh Coal's main contention all the way along in the proceedings was that the Fair Work Commission is not allowed to look into or inquire about whether an employee could have made changes to its enterprise and how it ran its business or organised its workforce, including contingent workforce, when considering whether it would have been reasonable in all the circumstances to redeploy an employee. So they essentially said you can't take it that far. You can only look at the employee whose position is redundant and the availability of other roles within the organisation that are vacant that the employee can fill. And that's been a fairly kind of standard approach, I think, and an accepted approach to that question, at least from an employer's point of view. So in exploring the scope of the Fair Work Commission's ability to inquire about what would be reasonable in all the circumstances around redeployment, the majority judgment actually looked at the various aspects of Section 3892 and said the term redeploy is not a limiting term. It doesn't, by its ordinary meaning, exclude or prohibit consideration of what changes an employer could make to its workforce in terms of how it uses its workforce to operate its enterprise. So the word redeploy doesn't exclude that inquiry around whether it would have been reasonable to redeploy. The majority said that redeployed looks at whether there was work or demand for work within the employer's enterprise or an associated entity's enterprise that could have been performed by the relevant or the redundant employee. So arguably that captures contingent labour hire. In this case, the Commission, the High Court said it's permissible to consider whether that captures contractors and for there to be an assessment of whether it would be reasonable to displace contractors and redeploy employees into those roles. Moving to their consideration of the term would have been, the majority in the High Court said this directs the Commission towards a hypothetical situation, being a situation that's different to what has occurred. So by the time you get to considering whether it's a genuine redundancy, you've got an employee whose role is redundant and the employer has, by reason of how it operates its entity, determined that there's no spot for the employee. The High Court said, well, the Commission's allowed to consider something other than that situation and go beyond that to say, well, hypothetically, would it have been possible? The reasonable element of the inquiry is important, and it's obviously an important qualification on hypothetical, but not only from the view of the employer or the employee, but in an objective sense. So the High Court is prepared to say that the Commission can objectively look at all the facts that are relevant circumstances and objectively decide about reasonableness. And that ultimately there's no hard and fast rules about this in terms of the application of the section, because the phrase all the circumstances confers a very broad discretion on the Commission around the scope of its inquiry into what would have been reasonable in all the circumstances. So this obviously creates some consternation for employers and a sense of, well, we're not really sure exactly what this means for us. Do we have to sack our contractors and put our redundant employees in their roles? Not necessarily. It's always going to be fact and context dependent. But what the case does give us is some key things to consider. And I think one of the first important things to take away is that redeployment doesn't require you to point to a vacant position. And if there is no vacant position, end the inquiry. It's got to go beyond that to think about, is there work or a demand for work within the organisation that the employee could perform? Now, that's not a complete answer to the question of whether it would have been reasonable in all the circumstances to redeploy, but it's certainly the first part, and it goes beyond just looking for vacancies. So a scenario which is not uncommon is for an employee to be called into a meeting and presented with a list of vacancies. Your job's redundant, but here's a list of jobs that are open. Maybe you might want to apply for some. Maybe you might have the right skills or qualifications. Some might be a demotion, some might be a stretch, but hey, they're open and vacant positions. This decision says that's not sufficient and really kind of challenges that thinking, and says that you've actually also got to look not just at the circumstances of the organisation around is there work or a demand for work that the employee could do, but what are the attributes of the employee in terms of their skill set, experience, training, competencies, and attributes of the employee's enterprise that could be matched with that. So it doesn't go so far as to say you've got to put unqualified people in jobs that qualified contractors hold. And I think initially that was some of the consternation around when the decision was first published, and perhaps not a lot of consideration had been given to what the fundamental principles that we can extract from it actually tell us, but certainly consideration of the employee's attributes, skills and abilities is relevant beyond the job they were performing when they got made redundant. So let's have a look at perhaps some more practical implications of that decision. And I'm just mindful of time. We're about to hit an hour, which will take us a little over time. So if you do have to drop off the call, the webinar is being recorded and the recording and slides will be distributed. So you'll get those. But just to perhaps take the discussion in a more practical direction around what this decision means for employers considering making redundancy decisions. I've already said it, I think, twice, but the notion of vacant positions only is now not going to be enough when considering potential redeployment, certainly a starting place. The consideration should go to what adjustments to the workplace operations could be made to make that work that's available, that there's a demand for, available to that redundant employee. And it's not necessarily going to require significant changes, but employers may be expected to adjust service contracts or third-party arrangements to allow employees to take over contractor duties. And I think we're going to see that becoming more relevant and applicable to contingent labour hire than to skilled contractors for obvious reasons. You know, if you've got a boilermaker who's being made redundant, you're certainly not going to pop them in performing the work of a qualified electrician contractor, for example. In terms of the contingent labour hire, the focus, like I said at the outset with this case, was really an opportunity for the MEU to really test whether some pressure could be brought to bear around what was discussed in the decisions as insourcing. So work that's outsourced to contractors ostensibly and which is capable of being allocated to redundant employees is going to be work that would be capable of being insourced because it's being outsourced. So that points directly to that contingent labour hire that the redundant employee potentially could have performed that work. It's not an absolute obligation though, and I think that's where the concern when the decision initially came out, and clearly it's still very new, it's not an absolute obligation, and there's a real weighing up of a range of factors that need to be considered. And I think that as long as employers are taking the level of inquiry about what's available to them or to their employees who are redundant around redeployment beyond vacant positions, then they're going to be taking significant steps to mitigate this risk. Interestingly, not only vacant positions, but positions that may become vacant because of a known or impending departure or retirement were also identified as redeployment options that employers should be turning their mind to. And I found that interesting because before the decision was made, that had arisen in relation to a matter I was advising a client about. And it was a position that was currently being advertised and was going to be filled because a successful candidate had been identified. But before we had this final High Court decision, there wasn't a final sense of direction on where that would land. But that in itself is probably another type of redeployment opportunity that an employer might have to consider. Now, this was before the redundancy decision had been made, but in circumstances where the employer knew it was going to make a redundancy decision, just after it filled a vacant position with another candidate. I think the key for employers is going to be stopping to ask those questions and explore beyond vacant positions. That will be the best risk mitigation measure on this point. But it's fair to say that this decision will probably be the catalyst for future non-genuine redundancy claims in the Fair Work Commission, whether it be because they have merit or whether it be because people are still figuring out, particularly employee advocates, are still figuring out how they can use this to their advantage, essentially. So I hope that's been helpful in covering off what is a epic piece of litigation and at times complex High Court decision in the very limited time that we've got. That you can stay connected with us either via our newsletter, LinkedIn, or our website. And if you've got difficult decisions to make around dismissal, reach out anytime. There's a little bit of information on the slides about our team, which you'll get when they come through. But thanks again, really appreciate you joining us and hope that that's added some value. Have a great afternoon.